Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Friends, in the CPC section 11, that is res judicata, is most important universally accepted principle. All of you know that. When a res judicata means a thing already adjudged, already decided. So when a thing is decided, so the person should not be vexed with the same case by filing another case. This is the principle behind res judicata, section 11 of the CPC. This res judicata is applicable between both the plaintiff and the defendant and co-defendants also. For any person, once the matter is settled, it should be taken as final. You cannot go for another case. There are other avenues for you. You can go in appeal, you can go in first appeal, you can go for the second appeal like that. But you cannot file a second case if the matter is directly and substantially the same. So this is what I told you yesterday. The Supreme Court very recently on 27th of August gave a decision that res judicata will apply to the co-defendants also. So this is, you can read this case as Union of India versus SV Narsimhulu Naidu, and he is dead actually. So 2013. So this was a civil appeal number 2029 of 2013, and it is decided on 27th of October 2021. Right? The citation can be seen LL 2021 SC 408. Two judges bench, Sanjay Kishan Kaul and Hemant Gupta, stated that res judicata will apply to co-defendants also. If you go into the details of the case, it will be better for you to appreciate the same also. So, you may not be knowing Sri SV Narsimhulu Naidu. He was an IPS officer. He worked in Prakasham district as Superintendent of Police, and he was the son-in-law of famous Chief Secretary Sri Samurthy Garu. During the year 1964, he purchased some land, some site, almost at the time it was 2 acres in Shekhpet, Hyderabad. Now you will be seeing Shekhpet is a very densely populated area nearer to Manikonda or Oasis Public School or that Subbarao, Dr. Subbarao House, Kakarla Subbarao House, very famous there. So on the northern side, Film Nagar is located. Now it has become a prime area. He has purchased it in the year 1964 and he sold it some others also. At the time some road has to come, and ultimately there was a dispute between him and the government, particularly the central government, army people I believe. So they stated that it is their land, and he has filed a civil suit against him. It was declared that he is the real owner of the property because he has produced all the documents, but the government wanted to acquire the land for construction of road or something in an area of 4,971.5 square yards. This is mainly the dispute. For this, Sri Narsimhulu Naidu Garu, yes, he said either you pay the compensation, otherwise you cannot retain the land. Of course, some agreement has been taken, and the case was decided in favor of Union of India in relation to that 497.5 square yards. Finished, that's over. Sorry, that was over. Because it was not over because he is not agreeable for the amount. Once again, this Union of India, without giving that amount, or since he is not agreeable for the amount, they approached the High Court. High Court also dismissed. Ultimately, the matter went to the Supreme Court. So, same thing happened. That is one part. Now, what happened is, now, very recently, maybe in the year 2013, the sons of Sri Narsimhulu Naidu is not now there. His son-in-law, Mr. Murali Krishna, is working as a DIG. So, his sons, since he is dead, they have stepped into issues as LRs. Yes, they have filed a case against the Union of India in the tribunal. That is, that the government of India has trespassed into their land because the entire land belongs to them. So they have once again under section 8 of the Land Grabbers Act, they have filed a case. Now the Union of India went in appeal. They stated that it comes under res judicata, because even though Narsimhulu Naidu and his sons, they will be co-defendants, the point is already the case has been decided in favor of the government in relation to 4971.5 square yards. Only regarding the amount they are fighting. And now the court stated that after going there, these people, they did not know that award was given that particular land, that particular piece of land. They may be knowing, but they have given the case. It's a different thing. But now the point is, when once the matter is decided, and that too, whether it is directly and substantially the same or not, this you have to take into consideration. This is not substantially the same, because this dispute is only regarding 4971 point of square yards. So if that is there, definitely res judicata will apply. Already the government has taken, Union of India is the owner of or is the administrator of the particular property, 4971.5 square yards is decided in their name. So these people cannot claim the same, even though their father died, even though there was a dispute, since it was declared in the name of Union of India. Yes, res judicata will apply. Please hear the case once or twice, and definitely it will enrich your legal point, whether defendant and co-defendant, whether the case against them will operate as res judicata. Now both of them wanted to fight against the Union of India. But since already the matter has been decided, yes, even the co-defendants also cannot get over that. So when they file the second case, it is hit by res judicata. So please remember, good judgment. So you can see it, SC 408, page number also I have given. You can see it, you can read it, and you can enrich your legal knowledge. Thank you very much.